We have been discussing something, isn't it? And Kuku has joined me. Good evening. Welcome
Thank
to
you
the
very
show. It's something that's sensitive and is also very important to all of us Ghanaians because we're a country now of many people who have migrated to other countries. And if you're a Ghanaian and you are 35 years and above, you definitely have some schoolmates that have migrated, particularly to the United States and to the United Kingdom. You have many schoolmates who have continued their education over there and have remained there for long years. Those who were born in Ghana in the 1950s and 40s, they don't have that kind of experience. They stay, work in Ghana. If they go abroad because the ministry is training them and etc. But the generation that was born from the mid-70s up through the 80s have this experience a great deal. Therefore, we have come to the point where some people who have gone abroad and have worked and want to come back to Ghana and want to come and do politics, one thing or the other, were knocking on the doors of the 1992 Constitution because after it was formulated, it did not permit dual citizenship. The 1992 Constitution did not permit dual citizenship. So a conversation began with Ghanaians abroad. Anytime President traveled and he met the Ghanaian community, they always tell him that we want dual citizenship, we want to be part of the Ghana story. So sometime in second term of Flight Lieutenant Rawlings, sometime in 1997 or so, the Constitution was amended to create a dual citizenship. But dual citizens were limited to the kinds of things they can do in Ghana and the kinds of things they cannot do. So since then, we have had a small, sizable amount of different people who have come through political appointments who have had to renounce their other citizenship. The recent one, the recent government is Charles Adom-Otchere, and there's another person. Renouncing citizenship. Charles Adom-Otchere.
He renounced, I think, US.
And then Madame, the lady who was a deputy minister of finance, was chairman of our board here at Metro. That's Mona Korte.
Okay.
Yes, Mona Korte also had to renounce her citizenship. We have seen the citizenship question that's come through Parliament so many times. Papa Kwesi Ndum had to deal with it. I believe that eventually he also renounced citizenship. And then came the question about qualifications for members of Parliament. When can one be qualified to be said to be a member of Parliament? The first sad case occurred in the 2008 election when Adom-Otchere, representing the New Patriotic Party and having won the Boku constituency elections, was found to have been a citizen of another country. The matter went to court and the court treated it in a certain way. Adom-Otchere was found guilty of, as it were, deceit of public officer because he filed the forms that he was a Ghanaian only. Now we're dealing with the controversial case of the Assin North MP who has had to step aside away from Parliament but is now awaiting a decision of the court to see whether something can be reversed. Many lawyers believe that it may not happen, but what we want to do tonight to take the next 15 minutes to sort of go through this process, and then as Ghanaians we can decide whether the nomenclature must be changed, whether the circumstances must be changed, etc., etc. So let me come straight to you, Kweku. So we're dealing with the case of Richard Kwesi and the Assin North parliamentary seat. That one, is it in limbo or is gone? Allegiance and citizenship. So explain to us, what does the Constitution say? What did the amendment to allow dual citizenship say?
Okay, so the amendments, formally, immediately you acquire the citizenship of another country, you lose Ghanaian citizenship.
Yes.
So the amendments, which was made in 1996, allowed persons who have acquired citizenship of other countries to also hold citizenships of Ghana. However, there are certain exceptions as to the offices such persons can hold. So such persons cannot be maybe on the Public Service Commission, for instance. Such persons cannot be ministers and other offices as expressly prescribed by the Constitution. However, there is a problem. And the problem is that per a common term of art, if you look at Article 94, which expressly says that a person shall not be qualified to be a member of Parliament if he owes allegiance to a country other than Ghana. Mm-hmm. And so there's a debate that allegiance and citizenship are not the same thing, and that if allegiance and citizenship were the same thing, then Article 8, which was the amendment, would have expressly put a member of Parliament there, that a member of Parliament or an individual who holds another citizenship in addition to that of Ghana would not qualify to be.
So people are trying to get us to say that allegiance here does not mean all citizenship to another country.
Yes.
How then? What are then the ingredients of allegiance?
It's a matter of fact that is determined on a case-by-case basis. Mm-hmm. And so if you look at the case of Bilson versus Rawlings, for instance, in that case, the court had to inquire as to whether or not Flight Lieutenant Jerry John Rawlings was a Ghanaian citizen. They determined that, in fact, by law, he was a Ghanaian citizen. But the court took an excursion to explain what certain positive acts of allegiance were. So swearing an oath to be part of the Air Force, actually going on missions for Ghana were all positive acts of allegiance. However, in other jurisdictions, there is a semblance of actually comparing citizenship to allegiance. The reason is that citizenship is a question of law and facts, which we can easily determine by face of it. You ask for my Ghana card, I give it to you, I show I'm a Ghanaian citizen. Allegiance, on the other hand, is relatively difficult. And so the Constitution, or people who support the argument that allegiance and citizenship should be the same, basically argue that if citizenship is a fact and allegiance is a notion that is difficult to be proved, then allegiance or citizenship should be the fact that proves allegiance.
Correct. I agree with that position.
So
because allegiance is sort of allegiance is in computer, you say software.
Yes.
Yeah.
Yes.
You really can't tell a person's allegiance by looking at his face.
Yes.
But you can tell a citizenship, and therefore we should isolate citizenship as the single most important ingredient in proving allegiance. Is that not so?
Exactly. But there are other countries actually do same. If you look at the United Kingdom, Britain, Australia, we have Britain, Australia, and Sierra Leone for the purpose of this presentation, but there are more if we would waste time.
Okay.
And so Boris Johnson, for instance, had to denounce his American citizenship in order to even move to Parliament or be elected to Parliament in the first place. Boris Johnson is an example. Let's look at Australia also. Now, if you look at the, Section 44I of the Australian Constitution, it provides that any person who is under any acknowledgement of allegiance, obedience, or adherence to a foreign power, or is a subject or a citizen, or entitled to the rights or privileges of a subject or citizen of a foreign power, shall be incapable of being chosen or of sitting as a senator or a member of House of Representatives. Now, if you look at the Australian Constitution, you observe that allegiance is mentioned and citizenship is also mentioned, right? So there may be the notion that, well, the Australian Constitution expressly mentioned allegiance, but let's look at how it was interpreted. Justice Brennan, in the case of Sykes versus Cleary, noted that the purpose of Article 44I
in the Australian Constitution,
is to ensure that no candidate, senator, or member of the House of Representatives owes allegiance or obedience to a foreign power or adheres to a foreign power, and to ensure that foreign powers command, and this is very important, foreign powers command no allegiance from or obedience by candidates, senators, and members of the House of Representatives. This is at page 113 of the report, which the case is reported.
But then if you are a citizen of another country, they can command your obedience.
That's it.
Yeah, okay.
So that's the rationale. If I'm a citizen of Ghana, I wouldn't want to say I owe allegiance expressly, but the government of Ghana can command certain things for me.
Yes.
If we are at war,
that you have to take a COVID vaccine.
Exactly.
Yeah.
If we are at war and the government decides to prescribe, we haven't left.
Yeah, go to war.
I have to, even though I'm a citizen of another country.
Yeah.
And there are many histories replete with such examples where.
So you think the argument that citizenship should be the proof of allegiance is sound?
Yes. Nobody can absolutely prove allegiance on the face of it. But what do we have? It's citizenship. We have to make use of what we have.
Okay, but let's come to the other matter of Ghana's parliament and all of that. The whole timetable of when a determination is made as to when the question is put and when the answer is taken.
Yes.
You see, because the answer is taken at a certain point. You can't take the answer now. So, for instance, Kwesi says that his process to renounce his Canadian citizenship is now complete. And that actually it was completed before the voting on the 7th of December.
Yes.
But by the time that he was filing the form, it was not complete, and that's the reason why he's in the trouble that he finds himself in. Now, the whole point about at which point should this citizenship, if it's about allegiance, at which point should it be taken? Because it means that on the day of voting, Kwesi's allegiance is sound.
Okay.
If it is true that by that time the process of renouncing Canadian citizenship is gone, then it means that on 7th December his allegiance is incontrovertible at the time. Why then, if allegiance is the most important thing that the Constitution says, what's the point then of saying he's not qualified?
So there are two answers. The first answer can be found in Section 18 of the Canadian Constitution, which provides that the citizenship is renounced upon issuance of the certificates and receipt of the applicants. And so that is when so you cannot say that because I have applied.
But he's saying that happened by the time the voting occurred.
Fine, no problem. But you see, then we have to look at the law. We have to look at precedents. So Republic versus High Court's General Jurisdiction ex parte Zenator Rawlings lays down the principle. In this case, what happened was that there were allegations that Zenator Rawlings, who was running for the Kolotikoli seat at the time, was not a registered voter. And because she was not a registered voter, could not be elected as a member of parliament. However, at the time the parties to the suit had sent the matter to court, it was not at the time she was to file officially her documents with the Electoral Commission.
But she was filing for the primaries of the party.
And so the court noted that in this instance, if it is your internal matter, it is your problem. However, once the party chooses her, and what she does concerns the Electoral Commission, that is when we use, or that is the time. Immediately the process is set in motion.
Yeah, but Dr. Rawlings' issue was not about citizenship. It was about being on the registered voter. Other forms of qualifications to members of parliament was not on the electoral roll.
It's a qualification.
It's a qualification.
Same with
okay, I get it. I get the point. So what's here?
So to recap, that's what Justice Bennett said in that case. To recap in a nutshell, the time when a Ghanaian citizen of 21 years of age can be said not to qualify or not to be qualified to contest for a seat in parliament because he's not a registered voter within the meaning of Article 1A of the 1992 Constitution is when the Electoral Commission, acting under the mandate conferred upon it by Articles 45C and 51, has declared that a public election of a member of parliament be held on a particular date and has also set the period for the filing of nominations by the prospective candidates. That is, and this is the important part, the eligibility criteria under Article 94(1)(a) will become applicable only when the actual electoral process has been set in motion by the Electoral Commission. For it is only then that the time could be imported into the said provision to make it completely viable and enforceable. So when did you file your forms with the Electoral Commission? That is what is relevant. And the rationale behind it is that from the time of filing to election, anything can happen, but we have to ensure that if you become a possible candidate for election to office, then everything about you is correct. Everything about you is
at the time the documentation is
finished. Because
and this is well known to all prospective candidates.
Yes,
they don't find out.
They have to, because the
so Honorable Christian must have known that
they must have been advised.
Yeah, that this process is going this way.
Yes, because the EC cannot be an appendix to an illegality. If I'm not an elected voter, if I'm not an elected voter, I want to run for MP for this seat, I cannot apply and file the forms. The reason being that in me doing that and the EC knowing, the EC becomes an accomplice with me in breaching the Constitution, which becomes problematic. And so the EC, as a creation of the Constitution, Article 40, cannot be an extension of an illegality as perpetrated by certain individuals, particularly when it breaches the same Constitution that established the Electoral Commission. That is the rationale.
So you are raising the point against those who are saying that once the EC passed him, you have to blame the EC. That's the point you're making.
Well, the thing.
Some people are saying that the EC sort of, because they went through a vetting process and they were said to have qualified. But I'm guessing that it will come within the context of the principle when you are going to University of Ghana or any university. They tell you that the documents that you have presented will be taken. If at any time the university finds out that something is wrong with the document, they will withdraw you, and you will lose your certificate even if you have acquired it. And
exactly, because there is so much.
Interesting.
There's so much.
But our people abroad are not happy with that. Our people abroad,
well, if you look at
you may very well end up in Harvard, and then after Harvard you go to Princeton, and then 20 years later your mother calls you and says that the people are asking for you to come and be MP. You come and be MP, and then you haven't. You never know. You never know. When you wear a suit like that, you have political ambitions.
It's for,
okay, I get it. But should we think of changing it to the young people who are looking at themselves as I'm going to get a PhD and come? And the process of this takes that long. An election happens every 4 years, it's not every year. Should we think of changing something?
If you look at the work of Parliament, it mostly happens at the committee stages. And the committee stages means they are privy to certain information that is sensitive. Security, public sector spending, and all of those things. If you look at the test as laid down by Justice Brennan, it means that it is possible for another state to compel allegiance from you concerning certain matters that may,
or even extract the allegiance.
Information. Yes.
Extract the allegiance from
allegiance
you. So you think it should remain as it is for the protection
exactly.
of the work that parliamentarians do?
Yes. If you even look at Article 8, which mentions certain commissions that they cannot be dual citizens. If you look at something, you observe that Parliament is the head, that passes all the laws, that regulates all these offices. Therefore, if Article 8 says that these offices cannot be held by dual citizens, then on what grounds are we saying that Parliament, which passes...
is there an argument like that dual citizens can be members of Parliament?
That's the whole thing. The allegiance is different from citizenship.
That argument must fall flat. The dual citizen cannot be. Not anywhere. It doesn't happen anywhere in the world, does it?
We show the examples.
Okay. So that's our presentation on this one, because we know the Supreme Court is going to have a look at it. So we are not the Supreme Court. We don't know what the Supreme Court is going to say, but we're just giving you, the viewers, the details, the information around this issue. Let's take a final set of text messages and we'll be done.